Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. This one might be a long one. It's a very short question, but listen, hopefully I'm not going to wax too poetic on this answer, but it's a bit of a long one. So we have a question here from YouTube user Anish. Excuse me, and I will try to mute the coughs, although I did just obviously miss that one. And Anish asked us, "Hi Vince, can you explain how much it is to file a motion for summary judgment? Can my attorney file it all on one page?" Okay, Anish, I like you. I like all of our interactions. This question frustrates me, and it's not your fault. I have lots of interactions where clients will be like, "Hey, you should file for summary judgment on my case." And my response would be like, actually, no. Like, there's no chance. Like, that's not going to get granted. There are various questions of... There's a lot of issues in this case. There's some legal issues going on that are unanswered in the case law. There's some factual issues. Like, we need a trial. In a variety of ways, we need a trial. And they'll be like, no, just make the motion anyway. And I'm like... no, you're talking about like 100 hours of attorney time that we are sure will not pay out. Like, we're not going to do that. The client will be like, oh, there's not 100 hours. Just like put in a page, ask for summary judgment. That's not how that works. That's not a thing. No. And so in some ways, Anish, I'm creating this video. So the next time somebody's like, just make a motion for summary judgment for me, I can send them this video and be like, so here's the reasons why that's not going to happen. Because we're not going to waste 100 attorney hours on a project that has no value, right? So let's dig in. Can an attorney file all on one page? Well, right off the bat, there's a lot of differences between summary judgment motions. Not all summary judgment motions are created equal. You're going to have the first question of where's the case pending? Like, if the case is pending in certain agencies, can you make a motion for? There's actually an agency that I'm aware of where you can say, "Your Honor, I'd like to verbally make a motion for a directed verdict. I'd like a summary judgment here. Can you just find for me?" And that fake judge, that administrative law judge, could theoretically say yes. Now, almost never would they, but they could, right? So in some scenarios, Anish, your idea of what a summary judgment motion is actually possible. It could happen, right? And so I'm not making fun of anything you're saying here, because I don't know where your case is filed. It's entirely possible that that's what you're dealing with. And even if that's not what you're dealing with, I'm not making fun of what you're saying, because you're asking a question, and that's the first step to gaining more knowledge, right? So we're together on this, sincerely. Now, if your case is not pending in that agency I described, more likely it's pending potentially in state or federal court, somewhere in this country. Excuse me. And generally speaking, a summary judgment motion in a state or federal court is going to be very, very time consuming. Now, the next question you have to ask is, if you're dealing with summary judgment, are you asking for summary judgment? Are you the one making the motion, the effort for summary judgment? Or are you opposing summary judgment? These are two very different things, right? If you're moving for summary judgment, you're essentially saying, hey, we don't need a trial. It's clear to everybody involved, I should win, right? And essentially what you're really arguing is we don't need a finder of fact here. There's no factual questions. If you apply the law, and the law is settled, if you apply the law correctly to the facts that everyone agrees them to be, I win, right? It's not really the standard for... That's an oversimplified standard for summary judgment, but that's essentially the argument you're making. In contrast, you could be opposing summary judgment. The other side could have made that motion, which is far, far, far more common in the realm of employment law when you're a plaintiff. Generally speaking, defense counsel will make a motion for summary judgment. They will often make a motion for summary judgment even when it does not have merit. right? On most cases, we will face a motion for summary judgment, and we will spend somewhere between 40 and 150 hours opposing that motion for summary judgment. In part, those motions are made legitimately because they can knock some claims out. Everybody knows there's still going to be a trial. But if defense counsel can knock out a couple of the claims we're bringing forward, out of all the claims we're bringing, that is potentially advantageous for defense counsel, for the defendant. Also, and let's not be too cynical, but let's quickly take a moment to note, defense counsel gets paid by the hour, generally speaking, overwhelmingly generally speaking. And if we think that your average summary judgment motion takes 50 to 100 hours to draft and make, to request summary judgment, and if we think, let's just be simplistic about it. If defense counsel is billing at $1,000 an hour, and they spend 100 hours in the motion, well, you can do the math. They just made some money, right? So it's worth noting that is potentially a motivation that goes on sometimes. Now, if you're the one making the summary judgment motion, asking for summary judgment, you are actually going to have a very high burden. It is a very high burden to be granted summary judgment, and meeting that burden is very time consuming. It's a lot of work, a lot to be done, right? So you might spend even more time. Right now, if you're opposing a summary, and also let me note, when you're making the summary judgment motion, that is a very creative endeavor. There's a lot of thought and creation and brainstorming that goes into creating those arguments as to why you should not need a trial. You should just win outright without a trial, right? There is still creativity in opposing a summary judgment motion, but it's creative problem solving. It's a little more bound by the realities of what the other side has filed because you're being reactive. You are responding and opposing to that motion. So while you're still creatively problem solving to defeat their motions and their arguments, right? It's not as broadly open as it might be if you were making the summary judgment motion. Now, those are the first kind of considerations. Those are the simplest considerations for how long a summary judgment motion might take. But let's continue. The next thing we'd look at is, what legal questions and what factual questions exist in the case. And we'll start with the legal first. Are the legal questions in the case at hand well settled? Like, is the case law really on point? You have direct case law. There's a lot of precedent in here. The law is not so much in question as it might otherwise be. Or is the case law really murky because there's not too many cases on point and you have kind of a novel issue, right? A novel issue is going to take a lot more time because you have to dig much further to find anything on point and you have to get more creative. So novel issues take much longer to argue, to correctly cite for and make your case law arguments and everything, right? Now, let's look at the facts. So the facts are really the star in a summary judgment motion. You're essentially arguing that we don't need a trial because a trial decides facts, right? And so we have to look at the facts. Are the facts objectively clear to any given observer? Or are they in question? Are they subjective, right? If somebody says, Nathan was walking towards me with the intent to strike me. Well, the objective part of that is every witness would probably agree that Nathan was walking towards you, right? That's fairly simple. He was walking, there was a direction. That's all we know, right? The subjective part of that is with the intent to strike me. Well, we've just read Nathan's mind. Now, listen, Nathan might have had his hand up, ready to backhand you, and that's a little less subjective, although it is still subjective, right? We're saying, well, I don't think he would have done it. Now, he's definitely going to do it, right? Instantly, question of fact. Was Nathan going to strike you, right? And we don't have the ability to crawl into Nathan's mind and say, yes, Nathan was feeling froggy that day. He did intend to strike you. Like, that's it's not something we can do, although that is in fact what a jury will someday be tasked with, right? Like, if this goes to trial, and if that's a key piece of evidence, if that's an element of some claim in this case, then the jury must decide, was Nathan in fact going to strike you? Is that his intent with walking towards you? And so let me tell you that if that is the subjective question we must answer in your case, sounds like we need a trial. Sounds like we might need a trial. Sure, his hand was up like this, but we don't know. We don't know. We can't say for certain he was going to strike you, right? In contrast, if the question is, you know, one of the elements of your claim is, was he walking towards me? All the witnesses agree. Both sides agree. He was, in fact, walking. He was ambulating in your general direction, right? Like, that's probably not a question. That's not a factual question. And if that's something you have to prove for the case and everyone agrees that it was happening, then, well, that's probably not going to be an issue. We don't need a trial for that, right? So, using that kind of silly example, how subjective the questions in the case are dictates, one, how likely this summary judgment motion is to be successful, but also how complex it's going to be, right? The mental gymnastics one must go through to argue that something is not subjective and is known and settled and agreed upon are far greater when the thing you're trying to prove is really subjective, right? Like, it's what do we think actually happened? We need to find our fact. That's a judge or a jury or an arbitrator, right? There's no question, right? In that scenario, we probably need a finder of fact to make a decision as to what actually was happening, even though, you know, we can't know for sure. Moving on. Brief story, right? So this is the criteria. This is what you look at to figure out how long a summary judgment motion is going to take. Now, story of stupid Vince. Stupid Vince, stupid young Vince. Fresh Vince, brand new to the field of employment law, was once walking around a law firm bragging about how he opposed a summary judgment motion in 20 hours. And stupid young Vince was like, I'm so good, I'm so fast, did great. And older, wiser attorney, older, wiser lawyer, we call them owls, pulled stupid Vince aside and kindly was like, hey Vince, hey, don't open your mouth about that again. You sound like a loser. Okay, Owly, older, wiser lawyer, but I did a great job. Probably not. Well, I opposed all their arguments. Probably didn't do that great of a job. Probably you went through and made the arguments, and they were the base arguments, and you didn't spend enough time on that to get creative and make really compelling arguments. You just made the standard you're wrong, here's why you're wrong, judge fine for me. And just doing that is probably not enough, right? It's not enough to say, you're wrong, here's why you're wrong, judge fine for me. There's another component, a much more time-consuming component of, and here's why you should find this argument compelling. And that portion of an argument requires the ability to persuade. And persuading is an uncertain science at best for 99.9% of humanity. And if you know somebody's really good at persuading, stop hanging out with them. Because it's only a matter of time until you're going to be their minion, right? They're going to be like, yeah, we should totally pool our finances and then buy me a really nice house. So, listen, natural persuaders, rare, and thank goodness for that. Now, if you're just making the arguments, can you dash off a quick, how quick is 20 hours, really? That's half a work week, right? But can you just get a quick 20-hour opposition to a summary judgment motion? Sure. Yeah, you could. It's probably not the best version of that document that you could have created. It probably missed some opportunities to reduce risk and potentially add value. It also probably failed to properly strike fear in the hearts of your opponents. make them feel silly for making this motion and make them worry that they're not going to get any traction with this motion, right? Part of what you're doing with a summary judgment motion, often, is when you're dunking on the other side, they're learning something. They're learning to fear you. They're learning that maybe we should have settled this because I look a little silly right now. And this might not have been the firm or the person that I wanted to make a bullshit motion against, just so I could bill an extra theoretical 100K, right? So you do want to teach them you can totally bill mostly nonsensical motions against certain firms. But you probably don't want to do it against our firm. And you want to do that because it makes your client's cases move faster. It makes your firm do less work because you don't have to spend time opposing nonsense motions, which are incredibly time-consuming to oppose. And generally speaking, it takes away a motivation for defense counsel to prolong your cases, right? Defense counsel knows, like, hey, this is relatively safe. This firm will not make me look bad, so it makes a lot of sense to keep billing on this case. I just want to keep it open. That's not ideal. But if defense counsel knows, the last couple times I got into it with these people at this firm, I did end up looking a little less than, and that's not great for my career or my business. So perhaps I'll go bill someone else a whole bunch of money, and I'll make a settlement offer on this case. Now, I don't know if your client wants a settlement offer. I don't know if you, as a prospective plaintiff, want a settlement offer, right? I don't know. But I think it's always advantageous to receive a settlement offer, right? If somebody wants to talk about giving you money, I've got lots of videos about this, it's important to listen. You will learn a great deal of information, even if you don't want that offer, right? If somebody's like, listen, I'll give you 100 grand, and I know you're not going to take 100 grand, but I bet you I could get you maybe 200. Okay, what do we learn from that? Defense counsel doesn't have authority for the settlement amounts defense counsel thinks should be offered. So defense counsel thinks your case is more valuable than defense counsel's client. So the trained, highly experienced individual who's not really that motivated to get your case settled wants your case settled. Why? They're concerned about this case. They're concerned about what it could do to their relationship with their client, the employer. Great. Tremendous. So we can probably extrapolate from that. The defense counsel thinks at trial they could lose big. Often, that's what can harm a defense attorney's relationship with their employer clients, right? So just in hearing that settlement offer, you've learned something. You've learned that perhaps defense counsel agrees with you about your case valuation. Or maybe they don't, but they do feel strongly that the case valuation should be higher than their own client wants to value it at. So you kind of know that they're in there being like, hey, listen, we should at least offer 200K, right? That they didn't float that out of nowhere. They had some reason to say, like, listen, on the DL, on the down low, I might be able to get you 200K. Listen, you as a plaintiff might be like, no, 600K is the number, right? That's fine. We're not settling the case. We're having a conversation about someone giving you money, and you're saying no thank you. That's fine. If you can engage in that without getting too angry, you can learn so much, as per the example just provided, right? And you're going to have more of those conversations if you establish your firm as a firm that's not a great firm to make silly motions against, because there'll be less reason for defense counsel to make silly motions and more reason for them to talk settlement. Even if your client doesn't want the money they're offering, you've learned things. Right? This is not it's not rocket science. Right? I mean, this is just follow the money to some extent. Now, Anish, it's generally not going to be one page. It's generally not going to be 20 hours. generally not going to be 500 hours. Generally not. I'm sure there's some firm that got stuck working a 500-hour summary judgment op. I'm sure. I'm sure that's happened in human history. But I think it's rare. Every single one is different for all the reasons we've listed. Every case is different. And so too is every motion. What's really at issue? What claim? Also, listen, remember, summary judgment motions can be partial. There are certainly summary judgment motions where like, hey, listen, the first 20 claims, they should all go forward. We're going to go ahead and admit that. But the last 4 sound like nonsense to us, so we want to make a summary judgment for those. Well, that's a much smaller motion. It's much smaller. It's less to argue for both sides. So the number of hours that go into that are going to be much lower. But I can tell you it's still probably not going to be 1 page. It's still not going to be 1 hour. And it's probably still not going to be 10 hours. And listen, different fields are different. We're talking about employment law. This is complex litigation. You can have, and I think people do have, summary judgment motions in the realm of personal injury that are like drop-down menus. Like, my client, drop-down menu, case law, drop-down, 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 argument, drop-down, good to go. Like, different fields. And not all PI firms operate that way. A lot of large ones, that's a tactic they might use, right? And then they have like a drop-down menu motion, and then they go ahead and they have a section where they type creatively to make further arguments, right? That doesn't work in our field, in my opinion. Listen, maybe some firm is making lots of money that way. I don't know. But it generally doesn't work. The possible ways to litigate a broken leg are actually... There's fewer ways to litigate a broken leg, in my opinion. And I am not a personal injury guy. I don't know much about personal injury. But from what I can see, from the outside of personal injury, like, well, there was negligence, there wasn't negligence, this, that. It's fairly finite, right? The possible ways for human beings to be nasty to each other are limited only by human creativity, right? Personal injury is limited to some extent by physics, right? There are physical laws in the universe, and you could say, but Vince, the quantum realm, and sure, I guess, but I don't know how often they're making quantum arguments in personal injury cases, right? In terms of, though, human nastiness, I mean, just look at any high school. Those children are like little factories of profoundly novel ideas of human cruelty. And they've got nothing but time on their stupid little minds, right? And that's what they do with that time. That's what they do. Like, they can't drive, half of them, right? So they're just sitting there like, I bet I could hurt someone. And then those humans grow up, and they're still doing the same things. Only, I mean, I guess back then probably too, but now they're in a workplace, and they're doing those nasty things motivated by some protected class. Like, I don't like this protected class, so I'm gonna throw out all the bagels every morning, because I know Cindy Lou likes bagels. And I don't like Cindy Lou because it's Cindy Lou's protected class. Well, good luck having a drop-down menu for Grand Theft Bagel. Bagel wastage. Like, what? That's not gonna. That's not a thing. It's not gonna happen, right? But and somebody out there's like, well, that's petty. That's not the entire case. It's just one part of the case, right? You're arguing like, listen, they wouldn't let my client eat at the lunchroom. They would destroy all the food my client could eat. That could be an act of retaliation. That could be an act of discrimination. We can talk about that. Would that be an entire case? No. No, I don't think so. Probably not. I mean, it could be, theoretically, but I don't think too many attorneys would just take the bagel case, right? But I'll tell you right now, for a fact, I've worked on cases. I'm not gonna give myself all the credit here. I've worked on cases where lunchroom evil, lunchroom misdeeds were part of the case, and the case resulted in a 7-figure verdict. Right? So we can call it silly or not, but like it's a reality, and there's not going to be a drop down menu for that. And there's not going to be as much case law as you might hope on the bagel debacle. Right? Like it's not like, well, and how are you going to prove why? Right? Why were they throwing out the bagels? Maybe they hate bagels. Maybe they're gluten intolerant. Maybe bagels choked their first puppy to death. The puppy stole a bagel and choked on it when they were 4, and they just hate bagels because bagels are puppy killers, right? Like that. Who knows what they're going to say? I don't know what they're going to say. That's the whole. So you go to a trial, you try to convince a jury. Now the bagel thing was just because they hate my client, because the Cindy Lou's protected class, right? And you need to find a fact for that. But if you're trying to litigate that in a summary judgment motion, God bless your heart. It's gonna take you a little bit. And it's a stupid thing to litigate because it's the most subjective thing, but like people will do it. So it's not a stupid thing to litigate. It's a stupid thing to fight in a summary judgment motion, right? Because it doesn't really lend itself to the decision-making process that's inherent in the burdens of, under a motion for summary judgment, right? So, Anish, no, it is very unlikely that your attorney could just make a one-page thing and seek summary judgment, although it is theoretically possible in certain situations, certain settings, certain venues, but it's very, very, very unlikely that that's what you're talking about. I think your attorney is probably dealing with a situation where such an undertaking for a summary judgment motion would be a huge undertaking, taking tens upon theoretically possibly 100 or hundreds of hours, depending on the case. So, Anish, hope all is well. I hope that you are fantastically successful in whatever you're litigating. And I hope that if this was helpful, you like, subscribe, comment down below. Helps our channel to grow. Take care, everybody.